Hello. Hi, I'm your neurofabulous friend, late diagnosed AuDHD, and today I'm talking about the thing that everyone keeps minimizing until it ends up in court. It's ADHD at work, or as it is often treated, the quirky but not serious disability, until someone gets fired, or humiliated, or put in an unsafe situation and blamed for it. So, in this video today, I'm going to kind of walk you through 3 recent employment tribunal cases involving ADHD, and I'm going to explain what discrimination actually means in the law, what ADHD or why ADHD is treated differently to other disabilities, and why one of the cases should have been treated as a health and safety issue, I think, and what reasonable accommodations really mean, and when are you deciding whether or not to disclose at work to request those reasonable accommodations. So, I do this as a job. Lols. I work in safety, risk, governance. I'm also trained with a Master of Law. So this is kind of my wheelhouse. This is what I get excited about. I'm also someone who has lived for decades masking ADHD and autism at work. So this is not opinion. This is law, risk, and lived experience. I'm super excited to dive in today. Now, before we get into it, if this topic matters to you, my book Unmasking Leadership goes deep into the psychological safety, neurodivergence, and why workplaces keep getting it wrong. Link is below. Please go check it out. Also leave a review because that keeps the book sales going. I didn't even know any of the stuff about books until I published one. Lols. All right, so let's start at the very beginning. Let's start with the uncomfortable truth. ADHD is one of the most misunderstood and infantilized disabilities in the workplace. Research constantly shows that adults with ADHD are viewed as less competent, less reliable, less professional, and even when performance outcomes are similar, all of these things are less. So, in a large review by Moeller et al. In 2012, it found that adults with ADHD experience higher workplace stigma than any other disability groups, particularly around organization, credibility, and emotional regulation. More recent work shows that ADHD traits are often framed as personality flaws rather than disability related needs. Things like disorganized, careless, unprofessional, not trying hard enough. Unlike physical disabilities, though, ADHD is routinely kind of moralized. You're not unwell. You are irresponsible. You're not disabled. You're just difficult. This bias matters because under discrimination law, that perception really drives further harm. So, if you want organizations to stop confusing personality with pathology, that is exactly what the book does. Just go have a read, just as a side note. All right, let's talk about what discrimination actually means. We need to clarify it and let's make it super clear. Discrimination is not about intent, it's about impact. So, for example, in the cases that we're going to talk about today, they're mainly based in the UK. So, under UK Equity Act in 2010, ADHD is recognised as a disability when it has a substantial and long-term effect on day-to-day activities. Discrimination can occur when an employer treats someone unfavorably because of a disability, an employer fails to make reasonable adjustments, an employer applies a rule or standard that disadvantages disabled people without justification, or an employee is subjected to harassment related to the disability. None of this requires malice, it just requires failure on the workplace's part. So this brings us kind of to the cases. Let's get into the first one. Case 1, Burns versus GitPod Ed Limited. This is the case often referred to as the sauna incident. An executive with ADHD and dyslexia attended a work-sponsored team building event overseas. She lost her room key. She could not access her room, And after drinking alcohol at the work event, she slept overnight in the hotel sauna. This just raises red flags from a health and safety perspective for me. Like, this is not even like, at this point it's like not even a discrimination thing. I'm just like, that is a solid health and safety thing. Her employer treated this as misconduct and dismissed her. The tribunal, however, did not. The employment tribunal found that her ADHD contributed to the forgetfulness and organization difficulty. So the employer failed to properly investigate disability-related factors, they failed to consider reasonable adjustments, and they dismissed her without understanding the role of the disability. The tribunal upheld the disability discrimination and failure to make reasonable adjustments part of the case. But I think this is where a lot of the people kind of miss the thing. This should have been treated as a health and safety issue. The worker was left without access to safe accommodation at a work event. If you are drinking at a work event, your health and safety person or your workplace relations person should absolutely make sure that there is like a secondary or a backup plan should someone drink themselves into oblivion. There is always a backup plan, so that blows my mind. Alcohol was involved, environmental risk was present, and responsibility was individualized instead of examined systemically. So from my perspective, this is not just discrimination, this is also unsafe work design, which I think didn't really get brought up in the case, which I found quite interesting. um you know just that especially considering that the UK has quite stringent health and safety laws. So case number 2. This case involved a senior technologist with ADHD. Occupational health recommended that ADHD awareness training for managers and colleagues were to be implemented at the workplace. Cap Gemini did not implement it. So this person was Coram versus Cap Gemini UK, and Cap Gemini did not implement the ADHD awareness training. The tribunal found that failing to act on occupational health advice was a failure to make reasonable adjustments. Importantly, this case confirms something really important. Reasonable adjustments are not just about the individual. They can include training, systems, and environmental changes. And you cannot say, "Oh, we did not know how to support you," when professional advice is actually provided and uber easy to get. This partial success still sets a legal precedent, which is really interesting. Now, most recently in the news, we've had Hogger versus Genesis PR. This one I think has made the news because like this poor woman's ADHD has been pathologized over and over again, and I've just seen the comments and it's just really disappointing. This case involved repeated comments about the employee being disorganized. The tribunal found that this language in context constituted disability harassment. Why? Because ADHD related traits were being framed as personality or personal failings, and the comments undermined this person's dignity. They created a hostile environment, and no reasonable adjustments were made. The employee succeeded on discrimination, harassment, and constructive dismissal. So it's really important to remember here that words are very important. Words matter. So especially when they map directly onto disability traits. So what can we learn here? What is the moral of the story? Hansel and Gretel, what is the moral of the story? Here is the pattern across kind of all 3 cases. In all 3 cases, ADHD was treated as a behavior, not a disability. Support was reactive, not proactive. Disclosure was ignored or minimized, and the risk was placed on the individual, not the system. And the tribunals are now clearly saying that this is not acceptable, which is great. But, what does that mean for people with ADHD? Let's talk about disclosure. Disclosure is not an obligation. It is essentially a risk decision because it might go really well, it might go really badly. Disclosure is not an obligation. You do not need to disclose. You can find ways for you to request accommodations without having to disclose. It's not critical for you to do that. And it is also obviously a disability, so it's protected. Here in New Zealand, the Human Rights Act protects that. I just find this really interesting because it should be up to the person, to disclose however much they're comfortable with. This should not be everybody has to know about your details or your dirty laundry, because again, we go back to that original research that says, ADHD is one of the most kind of discriminated or biased against of the kind of disabilities in this space. So let's talk about a couple of reasonable accommodations and what that could actually include. Things like changes in communication, changes to feedback delivery, adjustments to deadline or task structure, environmental changes, training for managers. What matters is the request is really clear and linked to functional impact and is documented. You don't need to disclose everything. You just need to disclose enough. And once disclosed, the obligation shifts to the employer. And that's really important. So if this video has helped you understand some of your rights, your risks, your options, blah, 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 please hit the subscribe button, share this around. And if you want kind of deeper insight into this, please go check out the book. I'm super excited about it. It seems to be going okay. The reviews are nice. And that's really important as well. Yeah, so I just want to make it super clear. ADHD is not a performance issue. It's not a character flaw, and it's not something tribunals are willing to dismiss anymore, which I find is awesome. We are not seeing a trend of oversensitivity. We're seeing long overdue accountability. So thanks for being here, and I will see you next time.